viewers, and my fellow mates. It, it gives me immense pleasure to welcome you all to this International Symposium Unity in Human Rights, jointly organized by the Center for International Law and Relations and the Pro Bono Club at the Vivekananda School of Law and Legal Studies. Today, we gather to explore one of the most pressing and foundational issues of our time, the advancement and protection of human rights.
As we celebrate the theme of the 2024 World Human Rights Day, equality, reducing inequalities, and advancing human rights, we are reminded that despite all the progress that has been made, many challenges persist in the quest to ensure that these rights are enjoyed by all. Thus, the objectives of today's symposium are ambitious, idealistic, and critical. We are honored to have with us today a distinguished panel of experts and thought leaders who will share their insights and experiences on these topics. So, without further ado, let us commence this important event.
To formally begin with the proceedings, I am deeply honored to invite Professor Dr. T.B. Subbarao Sir, our chairperson and mentor, to deliver the welcome address. Sir is an eminent figure in legal education whose work has continuously emphasized the lure of law.
Anybody is there with regard to rather inaugural? He is yet to join. Hello?
Sir, we can begin, sir. I have dropped him a message
Ah,
and I have called him also, but since he is in meeting, so we can start, sir.
thank you very much. It is my pleasure to address the guests that have come online for this important symposium on inducing equality and dignity in human rights, a wonderful topic that has been chosen, and I sincerely thank the charities of this program. Firstly, for choosing a very good topic in tune with the United Nations mandate. Secondly, for inviting me to join here. And these are all students which I see them in the classrooms. Now I could see them in different attire as anchors and inviting me. I am happy about it. Friends, fundamentally, we should note that human rights are irreducible minimum rights which are required for a human being to live like a human being with worth and dignity. That is why always they mention about worth and dignity. Human rights are those irreducible minimum rights which are required by a human being to live like a human being with worth and dignity. Human rights arise because of inhuman wrongs that we perpetuate against several persons in the society. Human rights are human concerns that one should understand. The word human implies that if one treats the other as human beings, like him, human rights are taken care of. Treat a person like human being, you will get a human being. That is the fundamental principle. Why, after so many years of establishing United Nations, after so many years, of 75 years almost of the Indian Constitution, still we are thinking of inducing equality. Is it necessary to induce? Still, treat a person like a human being and you will get a human being. The reason is that if you treat women as a human being like you, automatically women's rights are taken care of. If you treat child as a human being, child's rights are taken care of. If you treat disabled people or aged people as human beings, their human rights are taken care of. Human rights include gamut of other rights, my dear friends. Civil rights, economic rights, social rights, cultural rights, all these things, they are part of human rights. But I should tell you one thing. Long back, through a document ensuring human rights, you must have started with history 1215, Magna Carta. I am not bothered about that, digging out history again here. But the thing is that after that, you heard about Bill of Rights, you heard about fundamental rights, you heard about petition of rights. But the word human rights itself, you could find only in the year 1941, when Roosevelt has declared 4 freedoms: freedom of speech and expression, freedom of worship, freedom from want, that is more important, freedom from fear. If you achieve these last 2, automatically other rights are taken care of. It is a failure of League of Nations, because there was no provision for human rights except some protection for minorities, and especially the lessons we learned from World War has laid the seeds for human rights, and the expression human rights we started hearing. My dear friends, in the United Nations Charter also, women have to fight to retain the word, neutral word. Rather, human beings are created equal, instead of all men are created equal. That is the general expression that we use. The preamble started with "we the people" under United Nations Charter, not with the expression "the high contracting parties" as in League of Nations. My friends, I tell you, yet 7 places in United Nations Charter, you will directly find the expression human rights. Besides the preamble also, you can have 6 more with regard to several things. But the seriousness of it, you can find when ECOSOC established Human Rights Commission in 1946 itself. But it took till 1993 for General Assembly to create rather Human Rights Commissioner, and Commission on Human Rights replaced by Human Rights Council in 2006. My dear friends, Universal Declaration of Human Rights that you often quote, and Article 7 directly related to equality, you find Universal Declaration of Human Rights was not a covenant, but not a convention, but only a General Assembly resolution supported by 48 votes to none on 10th December 1948. It consisted of preamble plus 30 articles. I am not going into the details because it becomes a classroom discussion, my dear friends. The preamble expresses the commitment of faith in fundamental human rights and in the dignity and worth of human person and equal rights for men and women. That means all the things should be taken care of, not 1 or 2, my dear friends. And another thing is that you have subsequently took lot of time to pass the conventions. 1948, Universal Declaration of Human Rights. 1966, because of the Cold War started, division between American centers or Russian centers, you will find compromising covenants, 2 covenants at that time, with optional protocols, of course, subsequently. When India has given signature to it is also a question to be thought of. Besides that, specifically to maintain equality and dignity, you will find International Convention on the Elimination of All Forms of Racial Discrimination, CEDA. You will find 1979, Convention on the Rights of the Child and Convention on the Rights of the Disabled People. All these things subsequently one by one was passed because of the reason that in spite of having the covenants, in spite of having the commitment of the nations, we did not achieve equality. That is the reason why our people still are maintaining that we should conduct a program. United Nations wanted the equality program again to be conducted. And then you will also think about first generation rights, second generation rights, and third generation rights. That is third generation with regard to rather environmental rights and other things. Different generational rights are there, of course. But mind it, when rights are implemented country-wise, always they look from their angle. The first thing is that there is sometimes statist logic, their logic. Sometimes hegemonial logic. Sometimes naturalist logic. This is a better one, of course. And then supranationalist logic will be there. Transnational logic will be there. Populist logic will be there. There are various, nearly 6 methods of rather perceiving human rights country-wise. Why should there be so many things, my dear friends, is another question. Now, I take only one example. That example is with reference to discrimination relating to women. You may be wondering why I have taken that example to think about discrimination or inequality. The reason is that my entire career was with women's university and now predominantly women teachers. That is the reason. Okay. Look at how she is discriminated till now. I won't take much time because I have given you only 10 minutes time. I am going to wind up after highlighting certain things. The history of mankind is the history of repeated injuries and usurpations on the part of man towards woman, having in direct object the establishment of absolute tyranny over her. This is the word, this is the expression mentioned in Declaration of Sentiments of Women's Rights Convention in Seneca Falls in 1848. Is there any improvement, my dear friends? And then look at SIDA, 1979, what the statement? The full and complete development of country, the welfare of the world, and the cause of the peace require maximum participation of women on equal terms with men in the fields. 1979, is it necessary? 1948, Universal Declaration of Human Rights was passed. 1979, this Convention on CD was passed. One thing you should remember, women can do any job that man can do. But there are some responsibilities that men cannot discharge. That is correct. 100%, my dear friend. What is that? Now, for quite some time, they thought that only discrimination is the problem. But violence is
Subbarao sir, you will have to unmute yourself again, sir. After that, I think you got muted. Please, sir.
what happened? In the middle, you have stopped.
No, sir. Please carry on.
Yes.
From which point you have to rather tell? Did I start women's rights?
Yes, sir. You are on women's rights.
That is okay. Seneca Falls, I told you, na?
Yes, sir.
Now, my dear friends, it is in Vienna Declaration. It is in Vienna Declaration, and program of action was there in 1993. In that it was stated that human rights are universal, indivisible, interdependent, and women's rights are human rights. In which year? 1993. This was echoed in Beijing Platform for Action in 1995. Why? After so many years of adoption of Universal Declaration of Human Rights, they are telling this statement that women's rights are human rights. Till then, they are not. If you see the timeline of women's rights, how slow it is. In 1945, separate subcommission was established when there was already a commission. In 1946, Commission on Status of Women was established. Nothing was done. In 1963, they called for separate declaration because the existing declarations or conventions are not sufficient. In 1975, International Women's Year has come. And Mexico Plan of Action, 1975 to 85. And United Nations Decade for Women started in 1975 to 85. Most of you must not have been born. In 1979 only separate declaration, CEDAW has come. CEDAW came into force in 1985. Then India has given signature, my dear friends, with some reservations actually. And then National Conference, Nairobi Conference was held. 1995 Beijing Declaration. My dear friends, Beijing Declaration was attended and adopted nearly 12 parameters to be achieved to get the equality of women, to get women's rather things. In 2000, the General Assembly decided to hold special session. Every 5 years, there should be a review about the progress of 12 parameters that are laid by Beijing Conference. How much they have achieved. Till now, every 5 years, we are rather seeing internationally agreed development goals, including those contained in Millennium Declaration. They are not able to reach properly to women. So, my dear friends, even after Beijing Declaration, how much you are able to rather get equality for women is a larger question. Now, realities you can see. With this, I will conclude. Realities is that looking at Committee of Nations elsewhere, one can find with degree of variation only that discrimination continued, violence continued. Law is a digester of social reality, my dear friends. Whatever rhetoric we say, laws are seldom neutral. They are male specific, beneficial to men, male make rules and political judgments, and governance is in the hands of men. They are nowhere near in proportionate number in the governance. Who makes laws? Answer. Who makes, rather administer the laws? Who resolves the laws? It is he. Answer is he. Government, legislature, business, they are male specific, male constructs and cultural specific. Force is the universal tool of patriarchy, as I have told you. No religion is an exception to male domination. The erstwhile political philosophers in general approve If you go back to the ancient political philosophers, you will find that they have somewhere approved female subjugation. Dichotomy between public and private violence against women is another problem, my dear friends. And then low political participation is visible everywhere. Everywhere. People may say now women are getting more jobs, and they give example of IT field. My dear friends, I would like to tell you that it is flexibilization of market, not feminization of the market. Because women's labor is cheaper and there is no unionization as we think among women, because they are composed of different aspects. Poverty has women's face in developing, underdeveloped, and least developed countries, my dear friends. Violence perpetuates both against men and women, but who are most sufferers? As I have told you, given the examples of latest war situation, victims are chosen based upon gender. It is female focused. Violence affects family, cause the society of violent against women, I am telling. It affects family. It causes the society. Half of the population, if they are not able to participate in the development, how can you expect development? There is violence against women before birth. There is violence against women during childhood. There is violence against women during adulthood. When she is left, violence and discrimination are twin dangers that pull women back from take off. Woman wants equality, liberty, and right to life with dignity. Thank you very much, my friends.
Thank you so much, sir, for your thought-provoking words. Your emphasis on the role of human rights in protecting the women and children is a powerful reminder of the work that lies ahead. We are deeply grateful for your valuable contribution in setting the tone for today's discussion.
Now, we have the distinct privilege of hearing from Professor Dr. Dilip UK, Vice Chancellor of MNLU Mumbai,
Okay,
for the
Ananya.
inaugural address.
Ananya. So let me inform to all the audience present over here that Honorable Vice Chancellor Mr. Dilip Ulke, Professor and Vice Chancellor of Maharashtra National Law University, Mumbai, he is unable to join because of some meeting. However, he has requested one of his faculty, Dr. Amit Kumar. He is from Maharashtra National Law University, Mumbai, and he has joined on behalf of MNLE Mumbai. So, Dr. Amit Kumar, we would like to welcome you to this symposium. And here, let me tell you some background. So, this is a symposium, international symposium on human rights. And in this, we have invited various speakers, and they are going to speak on various themes which has been allotted to them. Even though Human Rights Day is in December, but however, we are conducting this symposium on the theme which has been given by United Nations to celebrate Human Rights Day. So on the same theme, we are having this symposium. So we would like to welcome you on behalf of Vivekananda Institute of Professional Studies, Vivekananda School of Law and Legal Studies. And just now you were listening the opening remarks by our chairperson, Professor Dr. T.V. Subbarao, sir. So welcome you. And would you like to share some of the thoughts or something?
No, thank you.
Yes, please. Would you like to add something?
Yes, ma'am. I think that was a masterful presentation from Dr. Subbarao. So nothing much to add. Also, I do not have a prepared speech right now. But one point of focus which I would like to bring to everybody's attention here is perhaps the intersection of health and human rights. Especially in developing countries and especially in the wake of the COVID-19 crisis, which we have just faced, and it perhaps might come back in some other form. A whole host of measures relating to human dignity have been violated. And I think it's now a moment when the world comes together and brings in solidarity in political form. The treaty formulation is taking place. I do sincerely hope that the North-South divide in this context is an opportune moment that the North-South divide gets bridged and we come together to fight pandemics such as these so that human dignity and rights are not violated. So that was my short message. Thank you for welcoming me. Thank you very much.
Thank you so much. In fact, you have highlighted a pertinent point that is regarding health. As such, health is one of the rights which is given in International Covenant on Economic, Social, and Cultural Rights. And in human rights legal regime, you will find that even though nowadays we do not use those nomenclatures like first generation right and second generation rights, but somehow according to those nomenclature, right to health comes under second generation right. However, I think right to health is required to be asserted more, and rather than taking it as a second generation human rights, we can take it as a collective human right or a group human rights for all the human beings. And I think
Absolutely.
thereby we will be able to give right to health more importance also. So thank you so much
So
for adding this point.
thank you, ma'am. Yes, in fact, now it's an opportune moment, as I was saying, to translate the second generation rights related to health to third generation solidarity rights, because especially in the context of COVID-19 and pandemics such as those, the third generation rights assume a lot of significance, and the consequent solidarity also assumes a lot of significance. Thank you.
Yes, yes. Please be with us, and we are again very much thankful that you are here. Thank you.
Thank you.
Yes, Anshita, please go.
Thank you, sir, for your kind words.
I now invite Professor Dr. Rashmi Salpekar, ma'am, Professor and Dean of VSLLS with TC to offer the vote of thanks. And we are also in gratitude to ma'am, as ma'am has also agreed to give us a brief on refugee laws. She has been a guiding force behind many initiatives in the realm of legal education
Okay,
and human rights.
Anshita, thank you, thank you. Yes, just like Dr. Amit Kumar, he highlighted one thing. So I also would like to highlight a point. But before that, I'm here to thank all of you, all the speakers who are here. So after all the speeches, of course, each and every my faculty member will express a vote of thanks also. But on behalf of Vivekananda Institute of Professional Studies, when we are welcoming, we thought that we should thank you also. I know it is afternoon and you people must have taken your lunch and maybe you wanted to complete your work before proceeding for your home. But however, we have just infringed your own space, the own space which you always celebrate after lunch hours. But we thought that, yes, why not discuss something on human rights? So let me thank all the speakers and let me take the names also. Dr. Vinay Kumar Singh, he has joined from Jawaharlal Nehru University. Mr. Sumit Parikshit, he is from Program Manager, NCP EDP. And then Dr. VK Tiwari, he is from West Bengal National University Juridical Sciences, Kolkata. And then we are having Mr. Mohit Khubchandani as well. He is from Leiden Law School. So we are welcoming you and we are extremely thankful that you have agreed to spare time for us and for our students. Now regarding refugees, only few points I wanted to highlight and which is in relation to our theme. So our theme, as just now I was telling that the theme is the same theme which we all entire world is celebrating, that is equality, reducing inequalities and advancing human rights. This is what is the theme which is declared by United Nations. Now when we are seeing that equality and reducing inequalities, and as our chairperson in his opening remarks, he also highlighted about rights of women, rights of children, I would like to move further by discussing rights of refugees. Now, we are required to think very seriously that will we be able to reduce the inequalities between citizens and refugees, citizens and stateless persons? Now, this is a question which now we are required to answer because there are, so many wars are going on in Middle East countries, and we know how disturbed area. Yeah, if anyone is planning to those areas like Israel, also I have seen that many people they visit as a tourist also. But now, of course, there are some limitations. So why is it so? Because of course the disturbance, the armed conflicts which is going on over there. I'm not into the declaration of war is there or not, and whether the rights of prisoners of war will be given or not. My only concern is that because of these armed conflicts, if they are, and certainly when they are producing refugees, will we be able to treat them at par with the citizens? Same with stateless persons, at least in the case of refugees, at least they are having some state, and state will also own them. But regarding stateless person, no state is ready to own them. Will we be able to reduce the inequality between a stateless person and a citizen? So this is a very, very long journey, but I think for the movement of the equal rights of women, for that matter also, women, they have crossed a long journey, and of course not only women but entire international community who were in favor of equal rights between men and women, and for that matter amongst all the genders. So you will find that there was a long movement. It is not like something, uh, for that matter, United Nations organization established in just 5 years, I would say. But however, asserting on the equal rights for women and others, there was a long journey. So of course, for refugees, for that matter also, even though it can be a long journey, but at least we should start. So regarding refugees, as you know, after Second World War, they thought that only few refugees are there which they have produced because of Second World War. So earlier, with limitations, somehow they have come up with a convention, refugee convention. Then after that, if you will see the historical background, then you will find that as per the historical background, International Refugee Organization, that particular, for short period of time, that particular effort has also been done. But then ultimately, ultimately UNHCR has taken up all the work of International Refugee Organization, and in fact, the refugees, that particular thing. So it was, they understood, or international community, including UN, they understood that it is not a temporary problem, but actually it is a continuous problem. So acceptance of a problem is also a step that we have moved forward. That yes, there is a problem, so that acceptance we have seen. And UNHCR also consistently, if you will visit official website of UNHCR, you will not find that UNHCR people, they were having some kind of rest in between, that no state is producing the refugees, so everything is going on well. It is not like that. So consistently, they are also working. They are also engaging various governments into dialogue, and they are trying their best to give durable solutions to refugees. Theoretically, if you wanted to prepare refugees, then in that case, refugee convention, of course, we are required to go through the refugee convention. In that also, refugee definition of refugee. Now, in the definition of refugee also, if you will see the contemporary research, contemporary literature, and also contemporary issues and perspectives. So many a times you will find that why not to add the climate refugees also. Now, let me tell you that the definition of refugee, and in all, whatever we have understood for refugee, it actually started with UDHR, that is right to seek asylum. And those countries who are not the members of Refugee Convention, they are also giving some, asylum. So what they are using the word that is asylum seekers rather than refugees. Like in India, India is not a party to Refugee Convention. So here in India, even though we called it as we are having refugees in Delhi, refugees are there, in Tamil Nadu, Sri Lankan refugees are there. But actually, they are the asylum seekers, and we have not conferred the status of refugee to anyone. Refugee is a status to be acquired. So a person or an asylum seeker is required to be so-called eligible to be called as refugee. So it is a status that is required to be acquired. And then only that particular person who have acquired the status of refugee, then he or she will be able to get all the rights which are associated with the refugee. Now, regarding India, even though we are not the party, but however, we are taking care of the durable solutions. For example, if you will see the Sri Lankan Tamilians, for that matter, voluntary repatriation, that particular durable solution, they means, we have implemented, and even now also maybe the process is going on. But long back when I did my research, so that time that process was going on. And then even for that matter, others also, like if you will see refugees from Myanmar have a voluntary repatriation. Tibetans, we are having a long history for Tibetans refugees. So generally they wanted to have, settled in our country only. So wherein you are taking refuge, there only you can settle. That is one durable solution. Another durable solution is that you wanted to settle in some third country, means not in your own country, not in the country wherein you have taken refuge, but they wanted to settle in third country. And voluntary repatriation means you wanted to go back to your country, but voluntarily, not forcefully. Regarding this, India, even though it's not a party, but however, we are respecting all the durable solutions. And Ministry of Human Affairs, in addition to this, UNHCR, for few of the refugees, we are taking their services. So this is how we are managing. And ultimately, it is Article 21 and 14 of our Indian Constitution. So under this particular legal regime, we are handling the cases of asylum seekers. For that matter only, we are having an office of UNHCR also in Delhi. So even though we are not a party, but still we are doing it. So my point is that refugee convention, even though there means refugee convention, even though the states are not the parties for this convention, but still you will find that all these ways are there so that we can protect the interest of refugees. So it is because EXCOM, as also what we call it as, there is a protocol as well, 1967, and this is how we are developing slowly and gradually the legal regime to protect the asylum seekers. Now, there is one more article which I should highlight, and then I will stop over here. That is a principle of non-refoulement, wherein you cannot compel anyone to leave the country. So now you will find literature to call it as customary right or non-customary right also. But it is a provision under Refugee Convention. So therefore, if you will refer the cases decided by the court, then in that case, generally we refer that whether we are the party to some of the convention or not. And we go for treaty as a source while deciding the case. So therefore, principle of non-refoulement, uh, even though international community, according to them, it is a customary right, but however, less evidence you will find that the states, they have followed it or accepted it as a customary right. But this is a key actually to solve the issue of refugees and also to reduce the inequalities as well. Now, even in Refugee Convention also, minimum rights have been given to refugees. Even though a state is a party to the Refugee Convention, but still minimum rights have been given. They cannot vote, right? Unless they cannot be the citizen of your country. Of course, as you know, you people are also casting your vote. Why? Because you are the citizen of this country. So refugee, they cannot cast vote. Then they cannot participate in any kind of, association also. And they are also required to come up. They are also required to report every time as per the duration, whatever has been given. But here, as Dr. Amit Kumar, he has also highlighted regarding health, there are many NGOs who, with the permission of the government, are looking after the health of those refugees. So even though health is a secondary right, and considering the Indian scenario also, Article 21 is there, Article 14 is there, and as you know, these are mainly the civil rights actually. Rest of the things, it is depending on the economic capacity, etc., including right to health. But however, for refugees, they are taking care of their health, they are taking care of their shelter, right? But however, they are not in the organized sector. Of course, they will work for some livelihood also, but they are getting some kind of financial support also. However, they are working in the unorganized sector, mostly in skill-based activities they are doing. For example, when I interacted with refugees long back, so I have seen that people from Myanmar, they are very much into beauty parlor kind of business, right? And refugees from Afghan, so generally they are into retail sector. So this is how slowly and gradually they are working, and no one is stopping them, but they are required to follow all the rules and regulations that is also there. Their children, they are going to school, and if you will see the policies of some of the state governments, like in Karnataka, even in NLSIU Bangalore also, you will find that few seats are reserved for these Tamilian refugees also. Professor Subbarao sir is here, so I think he uh, would like to add something in this. In Delhi, even though I have not seen in any university, maybe like if Vinay sir is there, he may tell us if in JNU, if there are some reservations for Tibetans also. But then in state governments, I have seen that they do give some reservations in educational institutions. And same with northeast states as well, because in north state is north east states also, you will find that refugees are there. So in all, again, if I will focus only on Indian position, we are not the party, but still somehow with the help of Article 21 and 14, we are taking care of refugees. Regarding the definition of refugees, whether it is a complete definition or what, but then there are issues. I have told you climate refugee, and one more as per the contemporary research which is going on, that why not to add gender, because gender based violence is also happening. So why not to add gender also in the definition of refugee? But however, yet no such work has been done on the definition of refugees. Many states, they are working on durable solutions, and one as a researcher which I always highlight, that why not to ask a state to pay something to the host state of refugees, because they are producing the refugees, but then again it is a long journey. But indeed, when I am reading this reducing inequalities and advancing human rights, I really think for the refugees and asylum seeker, that whether we will be able to reduce the inequality between citizen and refugees. Thank you.
Thank you so much, ma'am, for bestowing your eloquent knowledge on refugee rights and its various intricacies. We are thankful for your unwavering support and the leadership that has made today's event possible. And we are thankful for your in advancing the cause for human rights.
We now move to session one, which will focus on the implementation of the rights within human rights conventions. It is my honor to introduce Dr. Vinay Kumar Singh, Associate Professor at the Center for International Legal Studies, JNU. Dr. Singh is a renowned expert in international law and has made significant contributions to the understanding of human rights conventions and their practical implications. Today, he will shed light on the challenges in translating the ideals of human rights conventions into effective on the ground realities. Please join me in welcoming Dr. Singh.
Thank you, Ananya, for giving a very, what you can say, I don't know whether I could be able to justify my presence here or not. Let me to have some thought on the topic which has been allotted to me. Before that, I would like to thanks to Professor Dr. Rasmi Salpekar, being always been kind, always inviting me to VIPS, and I have been coming for long, what you can say, since last 10 years. I have frequently been with the VIPS, and it is really privilege and pleasure for me to be with all of you students from the VIPS. And also I thanks Aditya in terms that he comes to understand that what can I share my thought, which topic could be potential for me to reflect. That is the also important that context. I'm sure that I'm audible to everyone. Yeah, thank you.
Yes.
So let me to say that this is a very right time to have a discussion on what you can say, particularly human rights conventions, particularly International Covenant on Civil and Political Rights. Quick to add that one that India has submitted 4th periodic report in July 2024, very recently, and there were several comments, what do you say, observations from the committee has appeared. So this is the one first very close, very recent one, which could give us insight that how India has been also need to be seen in this context. Then also connecting with this one, you may also know in May 2024, maybe the first May of 2024, where the India's one of the national institutions for protecting the human right, that National Human Rights Institution, NHRC, National Human Rights Commission of India, was been not found to give the A status, accreditation status with the GNARI. There is a global alliance for the human rights institutions where India could not able to secure the A grade, which has been see that in that context that it would give opportunity to India reflect the views in the Human Rights Forum, particularly Human Rights Council. So these two important landmark in 2024 could be seen in that context to reflect the, what you can say, implementation of the human rights conventions, which topic is allotted to me. And again, to connect that, the title of the symposium is excellent, that including equality and dignity in human rights. So keeping these three together and trying to reflect how that could be seen in. One important context which I will tell you that India's reports, periodic reports, has been found that on certain aspects it has been found very promising in terms of like reservation of the women's, in particularly in parliament, which is going to be implemented by 2029, and it is appreciated by the committee. But committee also has what you can say shown concerns about India's progress, particularly related to ensuring the discrimination. And that's why this topic is relevant today in context of including equality and dignity in human rights. And this discrimination is being one of the what is thread into the whole comment which has been received from the Human Rights Committee. So let me to tell you just briefly what are the points which has been said by the committee, just to give you a crux to understand where we have been dealing on this issue. That one aspect, that is the corruption, prevention of corruption, it has not been addressed properly. Discrimination, particularly with against with the minority, it was being very much highlighted into it. Then again, the National Human Rights Commission, what you can say, the independence, autonomy, in terms of that one is being also questioned. Then these are the major, what you can say, point which has been come up into the, what you can say, constructive dialogue between Human Rights Committee and Indian delegations. Then with the particularly related to marital rape, this is also has been features into that one. Then abortions right for the women's also has appeared into it, that somehow transgenders rights, this has been also been made into it. Then you know very well that long times that basically Jammu Kashmir Public Safety Act has been questioned earlier also, and this time as well. So keeping this, what you can say, several issues before us to understand that what is important. But for the student, let me to also throw some light how you would like to see this instruments, human right instrument. There is a two parallel enforcement bodies exist in international human rights law. One is known as a charter-based system, another is a treaty-based system. Charter-based systems under which United Nations basically is being governed that aspect, and a Human Rights Council has been established by virtue of the UN Charter, and in which you know very well that there is a mechanisms in which the UN members are supposed to submit the UPR, Universal Periodic Report, which is different from the periodic reports which is submitted in the treaty body. So at present, now the one of the system which is being charter-based system, under which UPR is expected to submit by the India or other states also, whoever member of the United Nations. This is the Human Rights Council which oversee and see the implementation of the what you can say the guarantee given under UN Charter as well as another other convention as well. Parallelly, there is a charter treaty-based system under which several around 10 major human rights treaty has been so far concluded. And these treaty-based systems which allow us to basically to oversee, monitor the implementation of the human rights by the state parties. And you know very well that history begins with the Universal Declaration of Human Rights, 1948, UDHR, which consists both civil and political rights and economic, social, cultural rights together. But when this, as you all know, that UDHR is the General Assembly resolution, is the non-binding in terms of, but it is instead also it acquired the customary status in as a Magna Carta instrument in field of human rights law. And when the process further developed to ensure implementation of the human rights, there were two separate instruments came into being. One is known as a covenant on international covenant on civil and political right. Another is known as international covenant on economic, social, cultural right. These two covenant came into being in 1966 in terms of that adoption from the General Assembly, but it has been came into force in 1976. India became the party in 1979. And since then, India has been participating in the process of what consider submitting of the reports on them. This is the fourth periodic report which submitted by India to 2024. Now, this has, I'm trying to set the tone something and then we take forward that how the discussion could reflect on it. And keeping this in mind that at present the 173 member states have ratified this ICCPR, and this international covenant of civil and political right guarantees individuals' rights, particularly with respect to civil and political rights, right to life, right to equality, freedom of speech, freedom of religion, etc., etc., etc. Besides that, there are what you can say non-derogable rights has been articulated into the ICCPR, which is very contentious in terms of that. Often around there are a lot of issues, but for present understanding, there are rights under the ICCPR which is considered as a non-derogable right, which cannot be suspended even during emergency. These are the rights just for all of us to reflect on it: right to life, freedom from torture, freedom from medical or scientific experimentation, freedom from discrimination. This is the one important element which reflected into the India's periodic reports commented on that one. Right to equality between men and women. So these are the non-derogable rights, and take forward that along with this one Indian constitution, which provides Article 359 says that President is empowered to declare suspension of the fundamental rights, which is guaranteed under Part 3rd, except Article 20 and 21. So all other rights can be suspended by the President. So relate that one, that certain non-derogable rights are being there, but there are those rights also on certain grounds can be suspended. That has been also debated at length, but these could be an exceptional circumstance. Now, again, to reflect that India has, while ratifying this international covenant on civil and political rights, India has made certain reservations, particularly Article 1 with related to the right to self-determination. It says that it applies only to the peoples under foreign domination. Then with pertaining to Article 9, which says that right to compensation does not possible to ensure implement into the India. Then third one, that applying the India reserves right to apply its law relating to foreigners. So these are the reservation has been placed by India with related to ICCPR. Now I'm trying to set certain points before all of you, and then we can take forward into it. You know very well, recently few of the international instruments pertaining to human rights has been what you can say used before the International Court of Justice to bring the dispute before the ICJ to what you can say to implement it. and ask the parties to focus on it. And you know very well the instrument pertaining to charter or Convention on Limitation of Racial Description, search is particularly in focal point at ICJ. Several cases have been brought in. So, but what you see that in ICCPR, difference between ICCPR, civil and political right, and racial discrimination, that there is a specific provision has been articulated in Convention on Racial Discrimination to bring the dispute before the ICJ, which is not available in International Covenant on Civil and Political Right. So dispute related to application and interpretation of the convention cannot be brought before the ICJ under the ICCPR. So far we didn't, we could not see the disputes related to ICCPR at the ICJ. Again, that to little bit to underline the importance that ICCPR being known as particularly it is to guarantee the negative rights in the term that not to do that certain aspect has been there. But over the years, articulation has been done to ensure that there is an obligation of conduct has been there. And this obligation of conduct has basically brought that there could be positive, what you can say, way of measures to need to be taken by the state in ensuring and guaranteeing the civil and political right. So besides that, there are two optional protocol with the ICCPR. First optional protocol, which has been related to individual complaint mechanism, and the second optional protocol, which calls for the abolition of death penalty. This is the what you can see. These are the certain general aspect which I'm trying to bring before you. The ICCPR has the what you can say treaty body. Like every treaty has a treaty body. So ICCPR has a treaty body which is known as Human Rights Committee, which before which India made the periodic report and received the comment from the Human Rights Committee. This Human Rights Committee, there are 18 members. Major states often on these two there is a reservation has been placed by the states. India also had made reservation to that one. So individual complaint mechanism and interstate complaint mechanism has been not robust manner it is expected is been articulating in the ICCPR. Besides that, there was a methodology to proceed for the submission of the report, and there was a standard procedures earlier. Now they have made a simplified procedure to submit the report to ensure that timely state could submit the periodic report. This simplifying the reporting procedure is being I will tell you what could be essence of it. That in advance the committee would give the issues to be answered by the states, and states are required to submit answers only with related to issues which is being given by the Human Rights Committee. So earlier it used to be a very bulky reports in which what measures has been taken to proceed to know the progress on various rights made by the state. But now the issue based this instrument of that ICCPR is been somehow to be said that it is not as much as powerful as the search instrument is been there, which allows what you can say complaint dispute could be bring before the ICJ. As I said to you, in Indian context, that India and HRC has been not got a status of what you can say A accreditation from that one. Little bit, let me to highlight what is the GANARI, Global Alliance of National Human Rights Institutions. This is a This is a Swiss, what you can say, it is a Swiss association, and it is been registered with the Swiss government, Switzerland, and its role is being to see that on how the national human rights institutions from the all over the country could be bring at one platform to debate and discuss, to reflect about the human rights monitoring, implementation, progress, norm setting, all of these aspects. And NHRC has been earlier received this A status. It was received in 1999, then it retained in 2006, then it retained 2011, and again it received also A status in 2017. But in 2024, we found a setback, and the remarks was that NHRC could not able to operate independent from the government interference. Lack of pluralism being highlighted, particularly with the nomination from the women's commissions and as well as from SC/ST community. Only one woman has been found throughout the whole committees, which has been found objectionable by the committee. This has been something could be seen in this context that India's what you can say performance with related to human rights has found some certain setback to the international forums. In terms of that, India, though at the normative status, normatively within the government is being doing lot of things, but still at the implementation level, it has been found that it could not able to secure the work which is need to be getting done. So Aditya, how much time you have? It seems that I took 20 minutes already. Just last word to say on that aspect. This one comment has been made that about the NHRC that it could not able to what you can say adhere the Paris principles, which is being one of the cornerstones to provide the what you can say independency to the national human rights institution, and this is expected that this has been articulated. This what you can say NHRC has been established under the Protection of Human Rights Act 1993, which has been established only to implement the international covenant on civil and political rights. And you know, all of us very well know about that the whole debate about the giving autonomy to the NHRC, and somehow that appointment to certain key posts has been compromised. Could be, and one issue has been raised often in media, which also made to also somehow to get sense by the Geneva and New York, and that has reflected into the Ganari as well as with the India status periodic report. So I stop myself here. If we can take up certain questions, could be useful for to take forward the discussion. Thank you.
Thank you so much.
Thank you, Dr. Singh. Oh, yes, sir, you can proceed.
Go ahead, Ananya. Sorry.
No, it's okay, sir. Thank you, Dr. Singh, for such a comprehensive analysis of the obstacles we face in implementing human rights conventions. Your insights remind us of the gap between theory and practice and how much work remains to bridge that divide. We sincerely hope and appreciate your contributions to this crucial topic is beneficial to our audience. Due to paucity of time, we will not have a vocal Q&A session as of now. However, the audience
You
can
can
send the
pause for a
questions
second.
to us.
So, Vinay, if it is okay, we can skip the Q&A and we can mail you the questions because we are running a bit behind schedule. Completely on you, sir.
So there will not be question and answer. Now I can leave that meeting.
Yes, sir. So we can mail you the questions later and then you can respond on your own time, sir. If it's okay with you, sir.
No, that's fine. That's fine.
All right. Thank you so much, sir. Ananya, please go ahead.
Thank you, sir.
Now, as we transition to session 2, we will explore the human rights and pragmatic interventions of civil society organization in the context of persons with disability. We are pleased to welcome Mr. Sumit Parikshat, Program Manager, at the NCPEDP Emphasis Project to address us. Sir has been at the forefront of efforts to promote inclusive development for persons with disabilities, and today he will critically examine the discrepancies between policies and practice in this vital area. Please join me in welcoming Mr. Parikh, sir. We welcome you, sir.
Thank you, Anshita. Thank you, team, for inviting me for the session. So, as we are running behind the schedule, and given that we are constantly highlighting the paucity of time, I'll try to keep it as brief as possible. So, I'll request all the participants to just bear with me for 10 minutes. And like Aditya had suggested for Professor Singh, that we will skip the Q&A session. I'll also prefer that. And in case you have any questions, you can always reach me out. But I'll like to use chat where I would be sharing certain links which the team can say in case the other participants are not able to look into it and share it across. So the thing that I wanted to discuss is something that is not on the level of law, but at level of implementations, where we are looking at delivery of human rights through various angles. Now, when we say CSOs are necessarily civil society organizations, which is commonly referred as non-government organizations in case of India. So they work on various levels, and on one level they are agents to provide feedback to global policy frameworks as well as national policy frameworks, so that we have right policies and laws in place. On the other level, they are supposed to extend the outreach in places where the government is not able to deliver such services or information or products as effectively as may be envisioned. Okay. So this is how you can understand that when I say CSOs, you can kind of refer it to largely NGOs and institutions as such. So when I say CSOs, firstly, it is critical because it is reaching out to those targets which is not effectively being reached by private players as well as public institutions. Okay. Second way, it is critical from the standpoint that many of you who are students might end up joining working for a civil society organization based in India or even abroad. Okay. So keeping both in context, what I want to put forth is the idea that at times looking too minutely on the legal aspect, on the policy aspects, dilutes things at the time of delivery when we are concerned about human rights. And to, you know, look into this particular hypothesis, if I may say so, I'll use certain references. Okay. So let's take example of deinstitutionalization of children. They can be children with disabilities as well as without disabilities. So what is deinstitutionalization? So largely what we are talking about here is, say someone is destitute, okay, and needs social security in place for himself or herself. Then we have institutions in place which can provide that person with several facilities as well as services, okay, that ensures that the child has access to health, education, and as they grow up, even livelihood, so that they have a comparable living standards as any other children who is not a destitute, or maybe a child with disability who may not have a right ecosystem to support the development, his or her development. Okay. So taking this into example, now if you go by UNCRPD, UN Convention on Rights of Persons with Disabilities, so India is party to that, and given that we have to focus on deinstitutionalization, which means that instead of keeping children who need such places as a respite, we do not have institutions, rather we promote that the community embraces them within themselves. So instead of institutions, we are looking forward and saying that they equally belong to the society and they should be accepted. Okay, so this is what deinstitutionalization should look like. Now, the very basis that UNCRPD guidelines takes is that it has to respect the independence of that particular children. Okay. Now, how this particular thing gets affected when we talk about countries like ourselves? Now, there are reports emerging from institutions like NIMHANS. Okay. Now, before I delve into the report, I'll send you the general guidelines so that you can go through it, and followed by that, those very reports that are emerging lately. Now, if you will go through the reports of mental health, there are various reports which would illustrate, especially for these children who come in from the age of, are in the age of teen. Like, now, these are the children who would find you. There are cases where you would find them eloping from home with their partners or their love interest and ending up in different institutions under juvenile system in our country. Now, during this temporary phase, they develop certain relationships which make them feel part of the society, that particular community that exists within the institution. They feel safe because the society has not evolved on a level where they would accept such children back. Okay. So you understand how system of CAPS work and things like that. So such norms exist, and they feel that the institutions instead are much more safer places than going back to the community. Now, in these cases, we can say that the law or the policies that have been envisioned on a global level may not necessarily check all the evolving needs or say the needs of various groups equally. So, on those levels, if you will look into the work of NGOs who are focused on deinstitutionalization, they would be going by the fact that no, even if a teenage person is of is not of the opinion of going back to the community, we must counsel them to do so, which is against the thought of independent living, especially for that particular age group. Because if the person is decisive enough to elope, decisive enough to understand the realities of community back there at home or otherwise, then the person's opinion has to be repressed. But apparently, when these laws are formed, the opinion is taken from the adult side, not from the child side. So, if you will look into the research, even in case of academic research, hardly would you find surveys where such data points came from children. And that is where, on one hand, we can have a scenario like the recent case of Asha Kiran Shelter Home, where on a regular basis, cases have been emerging where the hygienic conditions have led to really poor health conditions or have recently gone to level of death as well, which is still being investigated. So there can be such cases where you can go for the fact that institutionalization is important, or you can have certain exceptions like in the ones I just illustrated. So that is where the civil society organizations fail to have that open space for such exceptional cases, and they keep promoting the ideas that emerged at a global level on a very superficial level and At times it feels like you are enforcing something with the idea which is just suiting your perception that you are doing good for the person. Okay. Now, second case, I'll like you all to go through a documentary that is old but remains true till date. So everyone is quite fond of bangles in the Indian context. Okay, the glass bangles. Now, because of the glass industry in Firozabad, we have families which are facing disability for generations because of poor working conditions in the factories that are looking into works related to glass. Okay. So, if you will look into historical annual reports of NGOs who were focused on child rights, now you would realize that there was a time before 2000 when they were highly focused on reducing child labor and their involvement in such workplaces. The moment right to education got enforced, the priorities have shifted. And when I say there is something that emerges as a red flag, so say I identified that okay, now the priority is also to look into right to education. But equally, it is important to realize the child is going to go to the school only if the family has basic the social security needs sorted. Otherwise, the poverty is going to force the children to dive into such business, which has been the case even now. So, what is happening here is that the priority has shifted, that is fine, but my target itself is not prioritized. So, if I say there is a scarcity of water, it means that scarcity of water equally applies for all the people living in that community. But if I suddenly say women have poorest access to water, then my idea is to prioritize that access for women first. But instead, I make 100% target of my deliverables as women only. So the point I am trying to make here is when the target shifts, when the priority shifts, be it because of political reasons, be it because how the laws say CSR laws have evolved, we do not deliver our programs in a programmatic phased out manner, in a priority based manner. We turn that priority into our target itself. That is where the people who at that point of time also required support are now suddenly out of that list of support. So that is where we need to have the intention where if we are transitioning into a new phase, we have to do it in a phased wise manner. So the old program, which was looking into child labor, had to be integrated with the program that was looking into rights to education in a much more holistic manner and in a much more phase wise manner. So you can check for yourself. If you will even look at NGOs who are focused on child rights in Firozabad, you will hardly find a few numbers. That too, working on protecting child labor and cases like that. Okay. So this is where the problem lies. Now, on a third level, where on the easiest way, make it very simple, where we take away the law from consideration because the law is there to have safeguards. Like if there is a law that you would be fined for not wearing helmet, I have a safeguard, but that necessarily won't promote a behavior towards personal safety. Okay. Secondly, the CSOs have to use academic data as well as global policies in a way that puts in priority the needs of the community that they are serving, and not blindly make the entire policy in entirety applicable to that particular community. Okay. The third is why such problems exist is because of you and me, which is very human. So I'll end up this session by doing a very simple exercise, and I hope that the conveners can allow hand raise during this particular section. So if those who are listening can raise the fact that given that we are educated, we are looking into such discussions, we are part of, say, so-called intellectual circles where we are talking about rights, especially of those who are marginalized. Don't we care about marginalized community? Those who agree with me can raise their hands. Okay, that was quite instantaneous. Now you can lower your hand and move to the second question. Now, out of those people who just raised their hands, I would like to ask them again, how many of you ensured that you offered a glass of water to the delivery person who delivered you certain things at 10 minutes time at cost of his life or her life? Now the numbers are suddenly going down, and there is a reason to that. That is simply human behavior. The laws were not in place to understand that the other person will also need a glass of water if it's a summertime. If you go to villages, you will still find places where you will find those earthen pots kept outside the houses, and everyone can drink that water. They don't even advertise that this was supported by or kept by some individual or some organization. The doors are always kept open so that if someone needs something, they can always enter the other's house. That behavior did not require a law to be in place. So it is you and me who has to question ourselves that on level of behavior, do we really need intersectionalities? Do we really need laws? Do we really need policies? Do we really need consultations? And do we really need portrayal of our intellectual selves to actually be just humans? And on that note, I'll end my address here itself. Thank you so much again for having me here.
Thank you, sir, for your illuminating words on civil society organization. Your work in promoting the rights of persons with disabilities, both inspiring and essential to the global human rights movement. We deeply value your contributions and the thought-provoking questions that you have raised in this conversation. Now we'll be breaking for a small break, and we'll be reconvening at 4:40. And the session will commence with Dr. V.K. Tiwari sir's lecture. So thank you so much, everyone.
Thank you so much, Sumit sir. Thank you, everyone.
Thank you.
Thank you, sir. Very good evening, Vijay sir. Can you hear us?
Can you hear me, Aditya?
I can, sir. I can. Very good evening, sir.
Very good evening.
So it's very nice to see you. Welcome to our International Symposium on Human Rights.
Thank you.
Thank you, sir. Sir, with your permission, if we can start.
Yeah.
Yeah.
Start.
Please.
Is my screen visible?
Okay, we'll commence. Next, within session 2, we are honored to welcome Dr. V.K. Tiwari, Assistant Professor at West Bengal National University of Juridical Sciences, Kolkata. Dr. Tiwari will offer us a historical perspective on the disability rights movement in post colonial India and discuss the peripheral embodiment of disabled and the questions of rights and dignity, mapping the disability rights and movement in post colonial India. Please join me in welcoming Dr. Tiwari. So you can start.
Thank you. Okay. Is my screen visible?
Yes, sir.
Yes, sir.
Um, so thank you, Aditya, for this kind invitation which you gave. And when you gave one thing which came to my mind that on what topic I should present. Um, And personally, I feel that disability rights question is very marginalized in human rights jurisprudence. And I was surprisingly happy that I saw that you have one module on disability rights, right? To be honest, even when I was teaching international human rights law, the paradigm was set in such a manner that even I did not include the question of disability in my international human rights law syllabus. So, this is my first proposal before I start my presentation is that human rights of disabled is a marginal question itself in the entire discourse of human rights. We talk a lot about women's rights. We talk a lot about children's rights. We talk a lot these days about pure rights, but disability right discourse is a new entrant. And we need to actually valorize this idea more and propose disability rights framework to understand the human rights jurisprudence. So that is why I thought that I will be talking about the peripheral embodiment of the disabled. And through this embodied reading, I would situate their human right discourse and link it with the question of human dignity. And I will be doing it through the mapping of history. Don't get terrorized by these big words like peripheral embodiments, etc. I will be deconstructing it while making my presentation. Um, so let's understand the entire rights discourse as like any professor of human rights will start, that all starts from the Charter of Magna Carta, right? So everything is started from 1215. We do that because our teaching is very, very Eurocentric, right? We try to trace the idea of history from Europe itself. And there is a reason behind it. The reason is that we think in a paradigm of enlightenment thinking, right? The enlightenment, the Renaissance, etc. And often we see it from the gaze of praise, right? A rational man was emerged, and the rational thinking emerged, etc., etc. But we do not question the problematic aspect of enlightenment, right? And in the paradigm in which we think. Michel Foucault pointed this out that the Enlightenment, which created the idea of liberty, also created the idea of discipline, right? And production of docile bodies happened through that enlightenment. Also, enlightenment, when Europe was getting enlightened, the flip side was that the rest of the world was getting colonized, right? So one populace of the world was getting enlightened and others were getting colonized. So what happened when I do a embodied reading of modernity and its allied secular science, it tried to present kind of a adult European bourgeois heterosexual male body. I repeat it, the adult European bourgeois heterosexual and male body as the normative standard, right? Some of you must be knowing about that picture which Leonardo da Vinci draw and call Vitruvian man, right? That's the perfect body size. And when this adult European bourgeois liberal body became the normative standard for all of us, anyone who does not fit into this normative standard was considered a deviant or other body, right? So even a brown male, even a brown heterosexual male in this idea was a deviant body, right? Because he does not possess the white body, right? Uh, as we saw the independence slowly and gradually, other hegemonic groups emerged in post-colonial societies. They asserted themselves as a norm. Disabled women, children remain at periphery, and that is why their bodies were called peripheral embodiments, right? So they are always the deviant, the other bodies, right? The leaky bodies, right? The bodies which need protection, the bodies which do not have their voice, right? The bodies which has to be protected, etc., etc. These bodies were considered as peripheral embodiments. What happened with this peripheral embodiment? The kind of a marginality has emerged. Now, I have taken a particular definition of marginality when I use it. And I have taken this definition by Latin, which says that marginality is thoroughly demeaning for your economic well being, for your human dignity, as well as for your physical security. Marginal groups can always be identified by members of the dominant society and can face irrevocable discrimination. Now, look into that. The kind of discourse which is happening through the judicial activism right now, right? I don't know how many of you have realized this, that Supreme Court, while giving us certain reasonable accommodation, is also taking somewhat a very, very patronizing attitude towards it, right? It's saying that, oh, we have removed the blindfold of the lady justice and now it can see the wealth status and can have, intersectional judgments. So, in this kind of a patriotic, patronizing, not patriotic, approach, what they do, that they present disabled people as somewhat defective nose, right? So it's not me who's talking about my human rights. It's the able-bodied people who are talking about my human rights. They are the one who are giving meaning to my lived experiences, right? This is what marginality is all about. Before I go into the appraisal of the disability movement, I would like to highlight a small portion of it, which will be benefiting for you in terms of reading international human rights law when you will be approaching the disability question. First thing you need to appreciate that in the present day, the dominant approach is the social model approach, right? The 2016 Act, which was passed by the by our Parliament, is based on social model. But that does not mean that the social model is the best model and you cannot have discourse beyond it. The first wave across the globe was the biomedical approach, in which you saw disability in terms of doctor's gaze. A doctor's gaze, in a sense that when you go to a doctor, he sees you not as a human personality, right? He does not see you as Vijay Kishore Tiwari, teaching somewhere, and all that, right? He does not invest me with those meanings. He sees me as a patient, he calls me as a patient, right? And he sees the defective body part which he is going to cure, right? So the biomedical approach saw this entire question of disability from this doctor's gaze. Okay, these are impaired people, they have this kind of a disability, and can we cure it or mitigate it? That was the biomedical approach. But slowly and gradually, a kind of awareness came through the critical writing that this is not the correct approach. And then we saw the advent of social model of disability. Now, what happened in the social model of disability? They said that impairment, when it is clubbed with attitudinal barrier, when it is clubbed with structural discrimination, when it is clubbed with situations where you do not have a proper facility for a disabled people, then it becomes a proper disability. So, for example, a student with disability, imagine a university where you have a lift, a student has a wheelchair, and you have a proper ramp, right? He will not have any problem whatsoever going to any classroom. But imagine if your university does not have a lift, you don't have any ramp, right? He does not have resources for wheelchair, right? Then his disability will become such a disability that he cannot access to any educational resource which is available in your university, right? The social model of disability also realized one fact that the biomedical approach to disability is mostly based on visible disability. So you must look like a disabled. You must, limp. You must fumble, etc., etc., which one can identify that okay, this person looks like a disabled. But there are psychosocial disabilities. There are disabilities which are invisible disabilities. For example, take type 1 diabetic person, right? Which is still is not recognized in India as a disability, right? But the person's um, pancreas is not able to produce insulin, right? And he has to inject insulin from outside. Now, just by looking at that person, you cannot say that that person is disabled. So, 2016 Act, however, recognized this that disability is an evolving concept. It is not a fixed category. And as the time will progress, a new meaning of disability might emerge. And the convention is wide enough to include the new disabilities which might emerge or the kind of concept which might emerge, which might say that these are the new disabilities which we need to include. So the preamble of the Convention on the Rights of the Persons with Disabilities has given you a fluid definition of disability. It is not fixed. It is not static. Right now, this is the third wave of disability movement at global context, where we are proposing that even the social model of disability is not it. And now the project is to debunk or to challenge the construction of ableism. Now, there was a philosopher named Thomas Kuhn who was a physicist and he wrote about physics. And he said that the science works in a paradigm, right? This paradigm term, which became very popular among among academicians across disciplines, is this that you think in a paradigm. So even if you have a social model of disability, if your thinking remains ableist, ultimately you will be thinking in terms of the way able-bodied people would think, right? So this project, which says that we need to actually debunk ableism, talks about that the problem is that there are networks of belief that present disabled people as a diminished body, and that has to be challenged, right? Now, in this entire framework, our Indian disability movement has emerged. I would give you a small story which not many people know. Recently, Professor Rohit Day has written about it in Indian Express. So the Deaf and Dumb Society of India approached the Constituent Assembly asking for granting equal citizen for all had little value to the people, disabled people, unless the discrimination built into existing laws were removed and disabled people were granted affirmative action in education and government, right? The Constituent Assembly answered them in one page letter, said that we have given you adult suffrage and that will take care of your concerns. You know what? The Deaf and Dumb Society of India was really furious, and they said that these promises are not going to help unless you provide us certain affirmative actions in education and employment. Also, you need to weed out those discrimination which is based on disability. Now, I would urge you to look into your constitution. I'm proposing a quick reading of your constitution. I say it's an ableist social contract which able-bodied people has imposed upon us. Why I'm saying so? If you just try to, control F, the word disability, right? Or disabled, only in Article 41 you will find the word disablement, right? Apart from that, these words are this is not being used. So what currently courts are doing, they are saying that Article 14 and 21 should be given a vast interpretation, but that does not mean that makes our existence in our constitutional setup based on the whims and fancies of individual benches in the Supreme Court, right? In the post-colonial India, initially the disability movement emerged uh, with Dalit movements and other subaltern movements, right? So, like any movement, the question was primarily in terms of asking for certain rights, certain concessions, etc., etc. And from 60s to 70s, which I have written here, you will find that as NGOs were pressurizing government, there was some kind of a engagement was emerging from UN. Slowly and gradually, we got in 1995 the first Disability Act, which was based on the medical model, right? I got my first disability certificate in 1997. That was the time when this act was prevalent, right? In that, you need to have one entire picture where you have to show through the photo that you are visibly disabled, right? In that, suppose if your limbs are amputated, etc., then almost you are standing naked before a cameraman, and the cameraman will take a photograph, and that will be posted on certificate. Imagine the human indignity of a disabled person who has to go through this process, right? So this entire debate was primarily into making them a normal people, so to say. Now we have come to this social model of disability. Uh, in this social model of disability, what we have seen, we have recognized that not only impairment but the social barriers also play a significant role. Professor Anita Ghai has pointed out a criticism which I really liked, and that therefore I it, presented here. She said that India's disability movement movement is primarily a middle class man's movement. If you just look into what are these things they are asking, so they are asking for concessions in airtable, hotels, parking facilities, etc., etc. These are very important, very important, aspects. But it is only for a middle class disabled, right? And the majority of the disabled come from the Dalit communities, those who come from, not so well from economic background, and their voices is simply not there in India's disability movement. I would add another thing that India's disability movement is very Delhi centric, right? So all these disability seminars, etc., keep happening in Delhi, and you don't see a lot of peripheral voices coming there, right? Just quickly, I would wrap up my problem with the current judicial activism on this. So you must have heard a lot about Vikas Kumar case, right? I would urge all of you to read at least paragraph 39 and 40 of that judgment, where Justice Chanchur says that disabled people are assets, not liability, right? This is a language of market, no? Assets, not liability. Also, he says a very interesting thing that they are insular and discrete minority. He has not cited it in the judgment. I hope that it's an honest lapse on his side. But this is coming from American jurisprudence, right? American Disability Justice Project is based on, um, insular and minority projects, right? And then you must have seen in this medical admission test case 7 days back, um, Supreme Court of India gave a list of good disabled citizens where they have mentioned Sudha Chandran and others that look, if you give them proper, facility, etc., they can do wonders. My only problem is that when you enlist these kind of good, citizens, you miss certain outliers. Where will you place Jian Sai Baba in that? Right? A disabled professor had a political ideology, and you incarcerated him for 10 years, and he recently died. Right? So what I call the neoliberal tolerance for disability does not account for outliers like G.N. Sai Baba, Stan Swami, or M. Mishra. And this is my complaint with India's, disability movement, that it approaches the entire question of disability justice from a question of hermeneutical marginalization and hermeneutical smoldering. What do I mean by that? That already if you are marginalized community, you cannot give meaning to your experience. Like Lady Justice with blindfold, right? You remove that and the blindfold is gone. Now she can understand reality, right? Or the elephant and the way blind men was touching and understanding. Only an able-bodied people can think like that, because I tell you, any blind person does know how would an elephant look like, right? And they also understand that people are rich, people are poor, etc., etc., right? If a minister is just in front of a poor litigant, even a blind judge would understand, right? So what happens that it's the able-bodied people trying to give interpretation to our human rights. And often what I feel that when disability justice movement is silent on these questions like Sai Baba and Stan Swami, they allow them to give interpretation of our lived experiences. And we need to go beyond that. The human right discourse on disability has a lot of potential, provided we have a courage to speak about it. Thank you.
Thank you, Dr. Tiwari, for your enriching analysis of. Sorry. Okay, sorry. Thank you, Dr. Tiwari, for your enriching analysis of the disability rights movement in India. Your discussion of the post colonial context adds a valuable dimension to our understanding of how these rights have evolved and where we must focus next. We are truly grateful for your contribution to the discussion. Due to paucity of time, we will not have a vocal Q&A session over here right now. However, the audience can mail the questions to us, and with sir's due permission, we can relay those questions to him, if that's fine.
Vijay sir, if that would be okay, if we can send you the questions later.
Yeah, sure, sure. No problem.
All right. Thank you so much, sir, for being here. You have truly enriched us. Thank you, sir.
So now, our final session, session 3, will address the advancements in human rights with a special focus on international legal studies and investment laws. We are pleased to have
So we
Mr.
can first ask Mohit sir, are you there? Yeah, you're there. So is it fine if we start a bit early? Yeah, we can't hear you. Please, if you Anshita, can you do the technical check with sir first?
Sir is not audible, sir, right now. So can you hear us? If you can just rejoin, there might be an issue with the audio.
Yeah, we do have 4 minutes, so it's fine.
Yeah.
Mohit, try getting rid of the AirPods probably. I don't know.
Am I audible now?
Yes.
Yes.
Okay, thank you. I'll take off the AirPods. Oh,
Yeah, Ananya, you
wait,
can.
one moment. It's connected again.
Anshita, you can start now.
Okay.
Yeah.
Okay, sir. So we are so pleased to have you, sir. Mr. Mohit Khupchandani, sir, is a PhD candidate at Leiden Law School, and he will be guiding us through the development in international human rights law and the implication for investment law in the global current landscape. So please join me in welcoming Mr. Khupchandani, sir. Over to you, sir.
Thank you very much. Am I audible now, finally?
Yes, you are.
Yes, sir.
Yes, sir, you're audible.
Great. So, good evening, everyone, and thank you so much for having me here. I am very, very grateful to the Vivekananda School of Law and Legal Studies and the Maharashtra National Law University, Mumbai, for inviting me to this international symposium on inducing equality and dignity in human rights. I think that there could not be a more important time in discussing these issues and see what we can do as international lawyers towards these issues. And through my intervention today, not only do I want to be the one speaking, but I want to hear from all of you and engage with you so that you can give me either comments or raise questions on how must we go forward. So I propose that during my 20-minute intervention, I will take not more than 15 minutes and leave about 5 minutes for you for questions and answers. And as I was saying, that we are in such an imperative and sensitive time during human history that we are in the scourge of two warlike situations in Ukraine, in Palestine. And as you would have seen, that despite the orders from the International Court of Justice, we are seeing essential humanitarian aid being prevented from being supplied in the Gaza Strip, let's say. Now, we've just heard from Professor Tiwari also about the rights of disabled people. And these are precisely the situations, warlike genocidal situations, which even lead to people being disabled. And as a result, unfortunately, weaken rights to these people. You would have also heard from some speakers, but if not, there are several human rights instruments in public international law, such as the Universal Declaration of Human Rights of 1948, the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social, and Cultural Rights, which necessarily govern human rights and human dignity, which is the theme of our symposium today. But what I thought I should focus on is looking at these pure public international law instruments from the lens of international investment law, because many a time that is where we need to operationalize human rights, including dignity of indigenous people, let's say, or labor rights. And very often, while we do make these discussions are not percolated in the international investment law regime, wherein actually we find a lot of corporations, conglomerates, and bodies flouting these rules and not giving the requisite protections to workers who are employed by them, and therefore not necessarily it is incumbent on the state concerned to exercise provisions under the human rights conventions that I just mentioned to you. So with this backdrop, let's take you back to almost more than 100 years ago, 1922. The Permanent Court of International Justice gave an advisory opinion at that point, endorsing the competence of the International Labor Organization for regulation of conditions of labor of persons employed in agriculture. Now, I will pause here for a moment because my endeavor today is to speak to you about these topics which are mostly spoken about in the state context, but not in the context of how certain investors and companies can deal with such issues. So agriculture, even in the Indian Constitution, maybe falls within state regulation and state conduct. But when we take it to the international scene, we can have a situation, let's say there is hypothetically company X having a big turnover, setting up some kind of a power plant in country Y, where the company is acting like an investor, therefore is being governed by either a bilateral investment treaty or a multilateral investment treaty. The only way wherein human rights can be enforced in that kind of a situation is actually not through the human rights conventions that I just spoke about. It is through these bilateral investment treaties or multilateral investment treaties, which should reflect certain standards and best practices from customary international law or principles of general international law in the text of these investment treaties themselves. Basically, what I'm trying to say is that now is the time when we need more convergence between pure public international lawyers and commercial lawyers who even practice international investment law. Because the reality is that even though we have the draft articles on responsibility of states for wrongful acts, that is RCEVA, for the conduct of an internationally wrongful act by a state, we don't have such principles for investors. So again, we then need to turn to these private instruments. And so as a corollary, it is important that the importance and the magnanimity of what investors do and the kind of power that they have is realized by us. As an illustration, according to Statistica, which is a body that calculates the annual turnovers of several companies, Apple's total net sales amounted to 384 billion US dollars in 2023. Now, this is in stark comparison to the entire GDP of more than 100 countries on the planet. So let's assume and let's try to imagine the power of certain investors, which is more than even many countries put together. So when we do speak about human rights and human dignity, it is absolutely impossible in today's day and age to enforce these rights without regulating acts of corporations. And so, therefore, what needs to be addressed is the asymmetry between strong human rights conventions and the lack of the same standards being reflected in international investment law conventions. Now, to validate this progress towards more regulation of investor conduct in the context of human rights, the ICSID tribunal, this is an investment law tribunal that deals with many investor state cases. So in the case of Urbacer versus Argentina, what the tribunal said was, I quote, "The international law accepts corporate social responsibility as a standard of crucial importance for companies operating in the field of international commerce. This standard includes commitments to comply with human rights in the framework of those entities' operations conducted in countries other than the country of their seat of incorporation." Now, what is important that the tribunal also says here, it can no longer be admitted that companies operating internationally are immune from becoming subjects of international law. The focus must be, therefore, on contextualizing a corporation's specific activities as they relate to the human right at issue in order to determine whether any international law obligations attach to the non-state individual. So you can see how tribunals have realized the importance of international human rights law and why it should be transposed in the international investment law regime. Just last year, one of the most robust international investment treaties is draft came into being. This still needs to be implemented, and the hope is that it will be implemented in the coming year or two. And I am also actually I am editing a book on investor obligations in international law. So this treaty is called the African Continental Free Trade Area Draft Investment Protocol. And this has some forward-looking solutions to deal with such situations wherein certain powerful investors and companies are actually dominating several countries' labor standards or human rights standards. So what needs to be done, and what to some extent this treaty has tried to do, is careful drafting of certain provisions and taking inspiration from hard law instruments such as the UDHR, ICCPR, and ICESCR, but also soft law instruments such as certain ILO conventions, certain UN human rights and business related reports, which can be included in the text of these treaties, and then they would be binding on the investors concerned. What is also important, especially in the context of labor rights and human rights, is how we try to delineate certain soft law principles from certain hard law principles, and what falls within the category of obligations erga omnes and what does not. It is very important because when we do the process of drafting and negotiating these treaties, if let's say we are speaking about something like child slavery, that has been argued as even an obligation jus cogens, that is a preemptory norm, obligations that states must not derogate from at any cost. And as a corollary, investors should also not derogate from these kind of obligations. So it means that even within human rights, there are certain obligations that at no cost states or these corporations should not derogate from. Now, in 1998, there was an ILO Declaration on Fundamental Principles and Rights at Work, and this declaration spoke about freedom of association, the elimination of all forms of compulsory labor, elimination of discrimination in respect of employment and occupation, a safe and healthy environment. So I ask myself this, is it enough for just states to take on these obligations? Because if it is only on the states to do this, then we will always have large investors with large turnovers flouting these rules. And that is why it is necessary for us to discuss human rights in the context of international investment law. And similarly, when we speak about indigenous rights, there is a famous ILO Convention 169, which speaks about rights of indigenous peoples. Now we are seeing investors set up their factories, power plants, etc., not just in cities, but also in less habited areas, which can involve an interaction with indigenous communities and their rights under these human rights conventions and equally under customary international law. So it is important that we tell these investors that just because they are not states, it does not mean that the obligations that were traditionally meant for states are not incumbent upon them. And the only way that it can be done is through introduce these stricter standards for investors in these treaties so that even states can have counterclaims in these investment arbitrations against the investors. And there are several such cases and instances in which this has been done. And for the paucity of time, I will not get into the nitty-gritties of those cases. But what I'd like to end my intervention with right now is to say that, for example, right now, an advisory opinion is pending before the International Court of Justice, and the International Labour Organization has asked the ICJ to tell the world what the right to strike means. Is there a right to strike under labor standards or not? We have it under certain domestic legislations, but internationally speaking, are workers allowed to strike if some of the freedoms that I just mentioned to you have not been given to these people? So with this, I will pause, and I am very happy to take any questions or hear any comments from you. Thank you.
Thank you so much, sir, for your insightful standpoint on where we currently stand in terms of human rights law on an international stage. Your analysis of investment law and its human rights implications has provided us all with a space for thought. And we are deeply grateful for your contribution to this critical conversation. And now, Aditya sir and Mohit sir, like, are we open to questions right now?
Yes, of course, we do have time. Answer also wants
All
to
right.
take questions. So yeah, please go ahead.
All right. So students wishing to ask questions can raise your hands and then, we can take questions for sir. Or you can also type it down in the chat box. We can read it out for you.
So in any
What
case, I can start.
sorry.
With
Yeah.
while the questions come in, I do have one. So of course, the BITs that are coming up these days, multiple BITs are coming, and you have also mentioned that. So are human rights provisions finding a way in them? And is that adequate?
Thank you for this very relevant question. And well, the glass is half full right now, is what I can say. We are finding such provisions in treaties, and particularly if we look at the, as I mentioned, the African Free Trade Area, Continental Area Investment Protocol, we have robust investor obligations in terms of their rights and obligations towards laborers, towards indigenous communities, towards the environment, which is connected with human rights many a time. And the language is actually what I call the shall language. Previously, we were seeing some kinds of provisions being introduced, but the language was more aspirational than enforceable. So the language was investors should strive to attain the highest standards. So this kind of language was there in previous treaties. I think there is still a long way to go. And as I mentioned in my intervention today, uh, that what needs to be done is a distillation of soft law instruments and hard law instruments, and try to stick to hard law instruments as much as is possible. The treaties that have a lot of state signatories are the treaties that will be more effective in investment treaties languages as well. So if we rely more on soft law principles, then we are weakening the text of the investment treaties. And I see this as an opportune moment, because you will understand that the process of negotiating human rights treaties can take years and decades, whereas investment treaties are easier to negotiate because they are at a bilateral level, or at maybe a plurilateral level, but still not involving all states. It can be at a regional level. So these treaties can then have a cherry picking exercise, and try to incorporate the hardest standards within them, so that we can enforce human rights and dignity in the broadest possible sense, and in a more enforceable way also, because many a time the human rights treaties that we are talking about can never even be litigated before the ICJ in the state to state context, because let's say if a state has some reservation either in the treaty or before the court, but in we have the benefit of at least regulating conduct of investors, because such limitations don't exist in investor state arbitration.
Thank you so much.
Thank you. Is there any other
Does
question?
anybody have any more questions?
So I think we can pause over it and mail the questions to sir later. Is that okay?
Yes, sir.
Yes, sure. If anyone has any questions that they feel hesitant to ask right now, or if you need time to formulate it, I'm happy to answer them later. And otherwise, I mean, no question is a bad question. So, like, please feel free if there are one or two more questions to ask me. And even if you might think, okay, I think there is one question now.
Yeah.
Okay, so yeah, this is also a very relevant question. The question is, what's the stand of India in terms of international investment law? It is a very interesting stand, because recently India has been terminating a lot of its bilateral investment treaties because in the past decade, India has lost many investment arbitrations against a lot of investors. And then what happens in an investment arbitration is that once the award comes, it needs to be enforced in a domestic jurisdiction. And it can be enforced anywhere. So awards that have been rendered against India have been taken to New York, to the Netherlands, to several countries, to Switzerland, to Singapore. So India has had to run from pillar to post to try and stop the enforcement of these awards. So yes, India has been terminating a lot of its bilateral investment treaties. And what happens is that when India does terminate them, then what kicks in is something known as a sunset clause. So it means that after the intent of termination is given, the treaty, depending on the language of the treaty, applies anywhere between 10 to 20 more years in terms of the investments that were already made under that treaty. Even though at the same time, recently, a few months ago, India entered into a free trade agreement with the UAE. So I think that going forward, India's stance would be to enter into such investment agreements with friendlier countries, with whom they don't fear any investment arbitrations coming.
So I believe you have another question.
Yeah. In which cases does the public interest require the damage of an investor to remain uncompensated? So if I understood you correctly, you mean that in which are the cases in which a damage that has been caused by an investor to a state will not be compensated towards the state? Is that your question? You can turn on the mic and correct me if I'm wrong. Okay, I'll operate in the premise that what I said is correct, but correct me if I'm wrong. So I think like what happens in an investment arbitration, that first there is a claim by an investor against the state. Until now, we've not had situations where a state is suing an investor, and that's actually a big burning discussion in international investment law, that states should be able to sue investors directly for the damage that they have caused. Now, the situations in which public so so yeah, there is a follow-up here. So not towards the state, but towards the workers and general public. I mean, what happens is that, yeah, so as I was saying, there is still not a situation where the conduct of investors can be regulated in terms of states suing investors. It's only investors suing states for something, and states have the opportunity to raise a counterclaim. And that is actually a fallacy of the system. And that is something that I feel should be changed. But when we are raising counterclaims, the situations in which the damage caused by an investor can be not compensated is actually certain technical grounds. Let's say if the bilateral investment treaty or the multilateral treaty does not provide for counterclaims, then the state is helpless, actually, cannot raise a claim. Counterclaims are sometimes under the applicable law, which is the domestic law of that particular state where the investment has been made. Now, if the domestic law of that state doesn't permit for counterclaims, that's another situation where where um, um, these things will not be compensated for. And I think speaking about public interest, that applies more to compensation from the state to the investor than from the investors to the state. So the state can say that it has lawfully expropriated certain assets of the investor in broader public interest because the investor was not complying with aspects A, B, or C of investment law. Um, yeah, that's my response. I see that there's another question. So I'm in your hands now. I can go on for a couple of more minutes, but if you are running short of time, I don't know. You can let me know.
Oh, I think we can continue. It's the last session, so it's completely fine.
Okay, great. So that's harder for me then. What can be the entry points to introduce new provisions for human rights in existing international investment law apart from trade agreements and treaties? So I mean, when I was speaking today, I was actually not speaking that much about trade agreements that relate to international trade law. I was speaking more about international investment law. So your question is relevant. And the entry points to introduce new provisions are certain provisions under international investment treaties that can be titled as, let's say, investor obligations. So if the investor does not comply with certain labor standards, certain standards relating to environment, then the state where the investor has made the investment is not required to give certain international investment law related protections to the investor, such as fair and equitable treatment, such as most favored nation treatment, such as lawful expropriation of the investor's assets, even if it has not complied with its obligations. So yes, the entry points are uh, specific provisions that are titled something as investor obligations in bilateral or multilateral investment treaties.
Sir, in case we don't have any more questions, can we conclude?
Yes, sir. Go ahead. Yeah.
We have another question, sir.
Uh, so it's on the speaker if they want to take it up.
Okay, I can take this as well. Earlier the questions weren't coming, and then I think I'm glad that there are more questions.
Actually, in the previous sessions, most of them have asked them to mail the questions.
Okay.
So I think they were ready with them, but yeah, please go ahead.
Okay. So the question is, how can states balance their obligations to attract foreign investment while protecting workers' rights? Very interesting question. Well, states should, like what the African Union has done now, states should come up with model investment treaties. So, model investment treaties are not treaties necessarily entered into between party X and party Y. So, party X being the investor, host state, and party Y being the state itself that wants to strike that balance. So let's say there is the Indian Model BIT of 2015. The Model BIT means it's a template. And if countries can show that their template BITs offer great protections to workers' rights, uh, and at the same time are not creating a lot of hurdles for investors in the definition of the scope of what an investment is, then I think that's a very balanced treaty wherein you are having lesser procedural obstacles for the investors to come in, and at the same time respecting your international obligations as a state under certain human rights treaties, and that is reflected in your model bilateral investment treaty or model multilateral investment treaty. Thank you.
Okay, thank you so much, sir. If anybody has any more questions, they can mail it to sir or to us. We'll relay the questions to them. Thank you so much, sir, for this insightful session. This session has particularly been very interactive and impactful for the audience. As we come to the close of this enriching symposium, we would like to extend our deepest gratitude to all our distinguished speakers for their invaluable contributions. Each of you has brought forward perspectives that deepen our understanding of the ongoing challenges and opportunities within the realm of human rights. To our organizers, the Center for International Law and Relations and the Pro Bono Club at VSLLS, thank you for making today's event possible. Finally, a heartfelt thank you to our audience for your engagement and participation.
We hope that today's discussion inspires further actions and reflections as we collectively strive towards a world that truly embraces equality, dignity, and human rights for all. As Nelson Mandela once rightly said, that to deny people their human rights is to challenge their very humanity. So let us together leave here a commitment to uphold these ideals in our communities and beyond. Thank you so much, everyone, for joining in, and thank you so much, all the distinguished guests, for taking out time for all of us.
So thank you, and I'll thank Mr. Mohit Kupchandani too for being there. Thank you for accepting our invitation. It was a pleasure to hear from you.
Thank you so much for having me, and great great audience here, great questions, and yes, I mean, in terms of questions, if you can collect the questions from everyone and maybe consolidate them, send them to me. Very happy to take this discussion forward, and it's very important that we discuss human rights and human dignity, especially in today's day and age. So thank you so much to Aditya and everyone else for inviting me here. Thank you.
Thank you.